Okay, welcome everyone. We've got some people joining. My name is Spencer Allison. I'm the marketing manager for Opus Agency. I'm helping run the show from behind the scenes here. So we're going to give people just another couple of minutes to join and get settled. If you've got any issues, you can throw them in the chat window. Yes, participants are on mute, so by default, if you've got a question, you can add it to the Q&A window, and we will try to answer as many as we can through the Q&A period at the end. We'll go over that too once we get started. And if you've got any sort of technical issue or anything, feel free to throw that in the chat window, and we will try to address it if possible. So I'll wait just another couple of minutes, and we will get started. Okay, guys, looks like we've got quite a few people in, so we're going to get started. And with that, I'm going to turn it over to Jenny. So.
Hi there, my name is Jenny Peters, and I'm the General Counsel of Opus Agency. Among other things, I'm responsible for helping the agency with data privacy, both from a compliance perspective and, when necessary, from a breach perspective. This area of law is super interesting because it's trying to keep up with the pace of technology growth, so it's very dynamic, and I'm excited to be talking to you about it today. So today you're going to learn a little bit about the legal landscape surrounding data privacy. I'm not going to cover every law on this topic because that would take a really long time. Instead, I'm going to be highlighting the main laws so you have an idea of how these laws work and how they affect marketing and events. We're also going to cover how to prevent a data privacy breach, or in other words, how to prevent being hacked. We're also going to cover what to do if you are hacked. Please feel free to type your questions into the webinar page during the presentation, and then I'll take 15 minutes at the end of the presentation to answer them. All right, so before we dive in, I want to make sure everyone understands what I mean when I say data privacy. The data we're talking about is the data that is associated with or that can directly or indirectly identify an individual person. As you'll see, different laws define data differently, but this is a pretty general definition. Data privacy is an aspect of information technology that allows individuals who provide data to an organization to be aware of whether and when their data is being accessed or used by a third party. I would argue that today the definition of data privacy is expanding to include providing knowledge to individuals about exactly how their information is being used as a whole. So why should you think about these issues? Well, nowadays, event professionals are always trying to go beyond simply putting on an event. You're trying to create an unforgettable experience for the attendee. We found that collecting and tapping into attendee data and preferences is a great way to do this. Event apps that can do audience polling and survey collection, as well as intelligent badges, are becoming the norm on-site. This type of technology is able to capture on-site behavior, mobile device usage, in-session engagement, etc., etc. However, you have to balance the collection of this individual data with the rights and preferences of attendees. People aren't going to be thrilled if they find that their information has been used for a particular purpose without their knowledge, and you risk damaging your business relationships if you're not transparent. Also, more importantly, data privacy is coming to the forefront of the global legal landscape due to events like the Uber, Equifax, Yahoo breaches. I could go on. Places like Europe are on the cutting edge of these issues and are treating data privacy rights much like the US treats free speech. For this reason, we want to give you event professionals a bird's eye view of the laws in this arena so you have a better idea of what your company needs to do and what you should be asking your attorneys. To be clear, none of this information in this webinar is meant to be legal advice. It's meant to bring you some awareness of what laws are in this arena and what hurdles there may be to compliance. This should give you the ability to kind of issue spot in your day-to-day tasks and highlight areas where you're like, oh, I think we need to talk to our company attorneys about this. Okay, so let's start with the General Data Protection Regulation, or as I'll refer to it, the GDPR. We're going to spend a lot of time on this law because there's a lot of different aspects to it, and because the penalties for not following it are super, super high. Okay, so the GDPR isn't quite in effect yet, but it will start being enforced on May 25th, 2018. If you're a company that collects any personal data at all relating to individuals in the EU in order to market or sell services to those individuals, or you monitor the behavior of those in the EU, you're subject to these requirements. It doesn't matter where in the world your business is. A quick note on the effective date: while May 25th, 2018 seems pretty far away still, you need to be in compliance for any events taking place on or after this date. If you're planning on keeping the data of past events past this date, you need to be in compliance with regard to that data as well. Since you are likely planning for spring 2018 events now, the compliance really needs to start happening now. So the penalties, as you can see, are pretty scary. For more flagrant violations, they can be up to 4% of global revenue, or 20 million euro, which is $23.5 million. So there are two categories of entities that deal with data under the GDPR. There's controllers, which are companies which are handling data or directing how the data is used, and processors, which are those companies that process the data per the instructions of the controller. An example of a controller would be an entity who is putting on an event, like your organization. An example of a processor would be Opus, or perhaps someone like Cvent or Validar, if you as the controller are contracting directly with Cvent or Validar. There also can be sub-processors, and that would be, say, if you're the controller, Opus is the processor, and Opus is contracting with Cvent or Validar. That would make them a sub-processor to Opus. Okay, so, oh, these are fun. Okay. The definition of personal data under the GDPR is very broad. It, of course, includes things like name and social security number, but it also includes things like IP address and social media posts. It includes information gathered via automatic processing, including profiling data, which means data showing certain characteristics of a person which are used to predict their future behavior or capabilities. All right, so there are quite a few aspects of this law. I'm actually not going to go into all of them, but I'm going to go into the most important ones for an event professional. And again, just be aware that there's more than this out there, but this should cover what you need to know. Okay, individual consent. So this refers to the requirements you have to meet before collecting someone's information. For example, when someone is registering for an event through a website, consent language would be found in that annoying little box of very small print language that you have to agree to before continuing. Consent must be given by a clear affirmative act establishing freely given, specific, informed, and unambiguous consent. This likely can be shown by ticking a box. That means physically ticking a box, not a pre-ticked box. Or they can choose technical settings for processing, or some other statement or conduct which indicates clear consent in the specific context. So what exactly is the person consenting to? Well, the data is being used, and when the data is being used in different ways, meaning for event registration or hotel booking, etc., consent should be given for all manners of use, meaning the language in that little box, or in the privacy policy that is also contained in the little box, should clearly show this. Additionally, the data subject should be able to tell the identity of the entity collecting the information and any other third-party entities using their information for any purpose. The data subject should be able to withdraw consent without consequence. Be aware that there are different categories of data, and consent requirements may differ based on those categories. For example, things like religious beliefs or political opinions are categorized as sensitive data, or in terms of event registration, if you ask about something like food allergens, this is something that requires a heightened consent requirement. Okay. Under the GDPR, individuals have quite a few rights. Once you've collected an individual's information, These rights include the rights to access, manage, correct, erase, and track. There's a few others too. Technically, the data subject can only enforce these rights against the data controller, but the data processor will need to help the controller out as needed to meet these requirements. So a note on automated processing and profiling here. As I mentioned earlier, profiling data does count as personal data under the GDPR and is actually subject to some pretty strict rules as set forth in GDPR Article 22. As far as consent goes, you must inform individuals of any automated algorithms being used to process their data or behavior and why you're doing this. This doesn't have to be extremely detailed, but detailed enough so the person has a reasonable understanding of what you're doing and why. Additionally, they must have the explicit right to opt out of this. There are obvious challenges in what it takes to describe an algorithm to the point of clarity that the GDPR requires. You'll need to talk to your technical team who created the algorithm, try to get a plain English explanation to the extent possible of how it works, understand where the data comes from and what's going to be used in the processing, develop a thorough understanding of how it's going to be used in practice, and then state all of that to the data subject. There's nothing to say that you can't also tell the data subject why they should opt into the automated processing. For example, say you have an intelligent badge at an event and you're collecting information through that badge about, a session that a person attends, the booths they visit, how long they stay at the booths, etc. There's an algorithm that processes this information and uses it to suggest other sessions, booths, or information that the person may be interested in. So once you explain exactly how the data is captured per the GDPR, then you can say, we encourage you to opt in so that we can suggest things that you're going to find helpful. You can tell the person, it's not all bad. We're not doing this just for us. We're doing it for you too. Also, I'll add that the GDPR does not apply to data that is aggregated and anonymized. So essentially, aggregated means grouped together, and anonymized means stripped of any identifying data. So if you want to get out from under the GDPR completely, do this before the processing and you should be good to go. Okay, protection of data. The GDPR also requires that you implement appropriate and effective measures with regard to data protection. This doesn't really require any specific measures, but experts have put together some guidelines. These include that data should only be collected for a specified, explicit, and legitimate purpose, and also you should only be collecting the information you need to carry out the purpose. So say you don't need someone's political views, don't ask for their political views. Data should be subject to pseudonymization and encryption as appropriate. Data should be stored no longer than necessary for the purposes for which the data is processed, and yes, this means backup servers as well. Your system should allow for recovery and restoration of lost data. At the end of the day, your security measures should be dependent on the severity of the potential risk to the right of the data subject. So essentially, you don't need to have as stringent of measures in place for someone's name as you would for their social security number. Regular evaluation of these technical and organizational measures should be completed. Okay, documentation. If you're a controller, you need to perform assessments called data protection impact assessments to document your operations and the purposes thereof, the necessity and proportionality of the processing, an assessment of the risks, and the measures you're taking to address those risks. If you're processing data on behalf of another entity, you don't need to perform these for your own organization, but you may need to help the controller out if they ask you to do so. Okay, subcontractors. If you're a subcontractor or use subcontractors to process information, each party's obligations will need to be memorialized in a written subcontract which shows the subcontractor's ability to comply with the applicable GDPR requirements and appropriately allocates risk between the parties. This is important and necessary for both parties, but especially for processors because it delineates risk in such a way to keep you from becoming a controller and thus being subject to more GDPR requirements. Okay, data breach requirements. A controller must notify the GDPR supervisory authority in the EU of a data breach without undue delay and, where feasible, not later than 72 hours. They must also notify the individual whose information was involved in the breach without undue delay, where the breach is likely to result in high risk to the rights and freedoms of that individual. A processor must notify the controller of a data breach on their end of things without undue delay. What does without undue delay mean? No one really knows, but I would say as soon as possible is a good guideline. Okay, DPO. This stands for Data Protection Officer. Both controllers and processors must appoint a DPO in their organization if they're performing regular and systematic monitoring of data subjects on a large scale, or where the entity conducts large-scale processing of special categories of personal data. This individual must be an expert on data protection law and practices, and their role is to be an advisor to the company regarding GDPR compliance and any issues that may come up. So, in a nutshell, if your company hasn't started to prepare for this, I would advise you to start as soon as possible. I know it feels overwhelming, and that's the case for everyone. There's a lot of good GDPR guides and articles online. Some of them are tailored to event professionals. So if you want to see more information about this, then I would start there. And I urge you guys to see this law as a way to prove to your customers and potential customers that you value them and are willing to do what is needed to protect their personal data. Okay, e-privacy regulation. Here's another EU regulation that has an effect on how companies all over the world collect personal data and interact with their customers and potential customers electronically. It's essentially the little brother to the GDPR. This one is an add-on to an existing directive from the early 2000s, and in a nutshell, it essentially protects the privacy of EU residents in connection with electronic communications, including the use of cookies and similar technologies, and in relation to electronic direct marketing. Okay, so this one also goes into effect on May 25th of next year, and its potential fines are unfortunately the same as detailed in the GDPR. If you've heard of this one before, you may have heard it referred to as the cookie regulation. It applies to the processing of electronic communications data carried out in connection with the use of electronic communications services. Electronic communications data means any content exchanged by text, voice, video, image, sound, including voice-activated devices, and even metadata, meaning data concerning the traffic of the message. Electronic communication services means services provided via electronic communications networks. Essentially, all websites and modes of electronic communication are subject to this. iMessage, Skype, Facebook Messenger, machine-to-machine interactions, and of course, email. This regulation applies to information of individuals or legal entities, which is different from the GDPR, which only applies to information of individuals. So there's three main aspects to this updated regulation. The first one is the e-privacy directive has always meant to be an opt-in law, and this means you must get people's consent to process and use their data in ways that you want to process and use it. The new regulation simply expands this to all electronic communication services, as we just defined, and adopts the heightened consent requirements of the GDPR for processing and use of personal data. If you use an individual's data for a long period of time, you must re-obtain consent at least every 6 months. Essentially, you're saying, hey, person who accessed my web page, we want to use your information to send you marketing messages, and they have to say, yes, I'm okay with that. Also, like the GDPR, certain technical protections are necessary, and when processing any electronic communications data. To get out from under this law, you do have the option to anonymize data before using it. Okay, cookie rules. So when I say cookie, just so everyone's clear, I mean a small file sent from a website which is stored on a user's computer that obtains personal data about them. The previous directive required that any storing or retrieving of information from an end user's device should be subject to consent unless it's technically necessary to enable the intended communication to take place. This led to an onslaught of cookie pop-ups, which I'm sure you're all familiar with. The e-privacy regulation intends to streamline the rules on cookies to prevent the overload of pop-up windows requesting consent to the use of cookies. The new provision on cookies provides that browser settings be taken as consent. This approach requires providers of browsers and similar software to provide users with cookie and tracking controls which should remove the need for the cookie banners and pop-ups and whatnot. Essentially, browser providers need to comply with the GDPR consent requirements in this instance. They don't need to be built into websites, which should be good news for all of you. Okay, marketing call rules. This regulation would ban unsolicited electronic communications by emails, texts, and automated calling machines. Marketing callers or emailers would need to be transparent about where the message is coming from, including displaying their phone number of use and a special prefix that indicates a marketing call. Users should be able to easily block a marketing call or unsubscribe from the marketer's call list. All right, now let's head over to Germany. The EU has what they call member states, like in the US, which may have their own local laws regarding data privacy and electronic communications. You have to be aware of these when you are doing business with or sending communications to residents who reside in these member states. One notable one is the so-called double opt-in law in Germany. Germany has really been at the forefront of data privacy legislation since the 70s. It's even in their constitution. The law is a good example of Germany kind of being a trendsetter here, and it's possible that laws in other places in the EU and really the world may move in this direction. Okay, so for double opt-in, you must get permission from the owner of an email address before sending any communication to that email address, whether it's in a physical list or signing up through your website or in some other fashion. This is the first step, and that's also the single opt-in, which is the case anywhere in the EU and in some other places in the world like Canada and Australia. But then you have to do the double part of the opt-in, which means that you must send an email to that user and ask them to click a link to confirm their subscription. You can only use their data per given permissions once they have confirmed. So this probably sounds terrible to some of you. However, I promise it's not quite as bad as you're thinking. List growth of a double opt-in list lags behind a single opt-in list only by 20 to 30%. Also, your subscriber list is going to be more engaged since they were the ones who were willing to go through two processes instead of one to be on your email list. So if you're concerned about this, I promise it's not the worst thing. There is a link here to a blog that I found that's a really good marketing analysis of single versus double opt-in. It doesn't really have any legal analysis, so just remember that there are certain places that, you do need to do double opt-in. Right now that's Germany. It may be other places in the future. Okay, so let's hop the pond and cover the US for a little bit. We're going to do the CAN-SPAM Act first. So this is an act that deserves a little more attention from those of us in the events sphere. CAN-SPAM stands for Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003 and covers email messages which have the primary purpose of advertising a commercial product or service, whether sent to individuals or businesses. It does not cover relationship messages, which are messages that are sent to existing customers and cover a certain transaction or information related to the ongoing business relationship. So, say you're trying to recruit people to register for an event of yours, and even if they're past registrants, this law is going to apply. However, if you're communicating with people about an event for which they have already registered, and that is really the bulk of the information in that email, then you don't need to worry about this law. This act doesn't ban spam outright, as you'll see in this law, or unsubscribe. There should be a clear unsubscribe button in all such advertising emails. If a consumer opts to unsubscribe, this request must be honored within 10 business days, and the sender cannot sell the person's email address to anyone else. The unsubscribe button option should be valid for at least 30 days after the message is sent. You can't charge a fee for unsubscribing or make the process complicated. So as far as content goes, the from line must be accurate, relevant, and not deceptive. The subject line of the email shouldn't be deceptive and should state that the email is an ad. There also must be a legitimate physical address of the publisher or advertiser from whom the message came. If the content is adult in nature, which hopefully you guys shouldn't be sending, this should be clearly stated or labeled. As far as sending behavior goes, this includes requirements like not sending to a harvested email address, The unsubscribe option must be below the message. The message should contain at least one sentence, etc. Also note that you cannot use automated means to send spam emails from multiple email accounts. The Federal Trade Commission has jurisdiction to enforce this act, and they can technically fine you up to $16,000 per non-complying email. They can enforce it against you if you are the one violating the act, or if someone doing email marketing on your behalf is violating it. There's been a fair amount of criticism towards this act as it supersedes state anti-spam laws, even if those laws provide more protection than the Can Spam Act does. Some call it the You Can Spam Act, as it seems to almost put a stamp of approval on spam practices as long as spammers follow some simple rules. Also, this is interesting to contrast with the laws that we discussed on the last two slides. This is a good example of an opt-out law. In the US, spammers can pummel you with messages all day, and it's completely legal unless you tell them not to. In opt-in jurisdictions like the EU or Canada or Australia, no one has a right to do anything with your information unless you allow it. As a practical matter, my advice would be to configure all of your communications to be opt-in communications, if not double opt-in communications. That way you'll tell people that you're planning to contact them, let them know why, and let them decide if they really want that. Laws are going to be moving in this direction anyway, so you can make sure you're covered in that sense. And really, the US is going to get there eventually, I promise. You'll be ahead of the game once they do. And really, people just appreciate it more when you're transparent with what you're doing with their data. Okay. So we're going to spend a few moments on some state-level breach notification laws in the US. Okay. Most US states have statutory requirements that you must follow in the event of a data breach. You can determine which state's laws applies by seeing which state the victim is a resident of. So if the data breach victim is a resident of California, then you would go see what the California statute says. These statutes define the type of personal information for which you must notify. This almost always includes first and last name combined with social security number, driver's license or ID number, financial account number like bank account or credit card number, combined with a security access code, a PIN or a password needed to access the account. There may be an encryption safe harbor depending on the state, meaning that you may not have to notify if this information is encrypted, even if it is subject to a breach. These statutes may cover more information like medical or biometric data, or even things like your digital signature. The statutes also cover the definition of breach. In almost every case, it's defined as a lawful or unauthorized acquisition of personal information, but in some states, even simple access may count. The statutes will say whether you need to do a risk of harm analysis before deciding if you need to notify. By that, I mean they'll require you to investigate a little bit to see if there's a likelihood of harm to those whose information was breached. There are different standards for this in different states. The statutes will state the situations in which you have to notify the state attorney general or the state government, if any. In some states, this is only the case if there are a certain number of victims of the breach in that state. Usually the number is around 500. In some other states, you need to notify the attorney general or government before you notify the individual, regardless of the number of victims in that state. The statutes will let you know the time frame in which you have to send the notification. It is usually between 30 and 90 days. They will say whether individual victims can sue you directly as well. Lastly, in some states like California, they'll tell you exactly how the breach notification letter needs to look. So if anyone received that beautiful Equifax data breach notification letter, that's what it looks like. I think they packed a lot of states into that though. So they tried to cover every state in that letter so they wouldn't have to send different letters to different residents. Basically it tells you things like what happened, so you know exactly what the circumstances of the breach were, what data was breached, and how you can protect yourself. So a note on credit monitoring here. Your company may choose, if you guys are the ones who are responsible for the breach, your company may choose to offer credit monitoring services for a couple years for the victims of a data breach. This is currently not required by any statutes, but it's something that attorneys may recommend to you that you offer because it may mitigate your damages down the line if the credit monitoring finds something suspicious and is able to nip it in the bud before it becomes a big expensive issue. Your company probably has cybersecurity insurance coverage, and this should cover credit monitoring for at least a year. All right, so it's also worth mentioning several other data privacy laws around the world. These are less scary and far-reaching than the EU laws we discussed previously because, frankly, their penalties aren't quite as bad. But it's still a good idea to be aware of these if you are present at events in these locations or collect data from residents of these locations. This is a very surface-level overview, and the laws I mentioned here are definitely not the only laws in each location. It's just kind of an overarching synopsis of what's going on in these locations. Okay, Canada. So Canada has the Personal Information Protection and Electronic Documents Act, which governs how the private sector collects, uses, and discloses personal information in the course of commercial business. This law requires obtaining consent from individuals before using their information in any way, as I've already mentioned, and also requires that individuals have access to their personal information, among other things. All right, Australia has the Privacy Act, which applies to government agencies, private sector organizations with annual revenue of over $3 million, and all private healthcare service providers, and then some small businesses as well. There are 13 privacy principles with the main goal of open and transparent managing of personal information, which include requiring a privacy policy, the collection of personal information, and direct marketing principles. So China just got a brand new privacy and cybersecurity law in June of 2017. It's called the Cybersecurity Law and subjects network operators to certain consent, collection, and use requirements with regard to personal data. It also has general security requirements, including malware prevention, vulnerability management, and protection of information that are applicable to network products and services sold or provided within the territory of China. Network operator would apply much more broadly than you would think, perhaps even to someone who has a couple of computers at home that shares files between them. So this is definitely applicable to those that are running a registration website. There are also certain requirements for critical information infrastructure operators. That definition is not yet clarified, but if you do qualify as one, you must conduct annual security assessments and have a genuine business need before storing personal information outside of China. There's a lot that needs to be clarified about this law, including what type of information would subject a company to such assessments. There are fines associated with a breach of this law up to $150,000, but as of August of 2017, only warnings to correct the issues have been issued. So this is kind of one to keep an eye on. Just be sure you're aware of it if you're doing events in China. So in Japan, we have, they also got an upgrade to their existing data privacy law recently, and they have the Act on the Protection of Personal Information. The upgrades establish a centralized Japanese data protection authority, much like the EU has. The new law requires consent for use of so-called special care required personal information, which is more sensitive personal information like medical or criminal history. Consent is not required for anonymized data. This is an effort to get businesses to erase personal information so it's not used in business analytics. There are certain data transfer and record-keeping requirements. Cross-border transfers of data, which means when a Japanese person's data is being processed somewhere other than Japan, can take place if the country in which it's processed has an acceptable level of security, according to Japan, and there is a contract allowing it, or per consent of the individual. Russia. So much like Germany, data privacy is in the Russian constitution. This constitutional act is called the Data Protection Act. This is another one where the law requires that any personal data of Russian individuals must be processed in Russia. The penalty for this is that your website is going to be blocked in Russia. So at least there's no money involved there. There are some exceptions to this, including the ability to process data outside of Russia if your primary or initial processing is in Russia. Some other aspects of the DPA are mandatory security regulations, obtaining consent of the individual before processing their personal data, including for direct marketing purposes, the individual's right to have their data deleted, among other individual rights. There's also the obligation to notify certain governmental agencies if you're processing information in Russia. So that's another one to be aware of for sure. Okay, so veering away from the legal landscape for a bit for some practical advice on how to avoid data breaches. All right. So really the biggest one is going to be employee training. You can train them how to recognize and avoid online scams, phishing, ransomware. Don't click on anything that anyone sends them, even if it says funny cat pictures or something. You should always be using the latest operating system and make sure the virus protection is up to date. That's something that the employee can keep an eye on their personal computer and their personal work computer. Train them on measures that businesses need to take to protect their information, as it's different than steps they would need to take to protect their own personal information in some cases. Train them on who to contact if they lose their computer or think they have a virus. We just discussed those state breach notification laws that have some strict deadlines, and making sure that people let you know if there's a problem immediately allows you to address it and not miss any of those deadlines. Really, this is something that you should embed into your company culture. There are some online training courses that your company can purchase for this purpose, or you can put together your own training. Regardless, having an educated, aware employee is a huge step in the right direction in avoiding problems with your company's collection and use of data. Okay, internal policies. Along the same lines, it's really helpful to put in place some robust and detailed internal policies on data and device usage. Make them comprehensive but readable, and have your employees review them on at least an annual basis. This can include computer usage, mobile device usage, how to deal with personal data that comes through their inbox, where to store information, etc. Okay, so a VPN is a virtual private network that encrypts all information coming to and from your computer. It can also mask your IP address, which makes it harder for unknown actors to ascertain your location. This is a great tool to use if you're an event professional who travels all the time and is often working in an airport and on hotel Wi-Fi. This gives you an extra layer of protection on those somewhat sketchy open Wi-Fi networks. Okay, security. So this is where you should rely on an expert, either in-house or external, to make sure that you have appropriate security measures in place. This can be encryption, firewalls, virus scans, etc. Don't just think about computers, think about mobile devices that get work emails, or say iPads on which registrants confirm their registration on site. If you have employees who work with personal data in their email, it is probably best practice to provide them with a device instead of allowing them to use their own. That way they have direct control, you have direct control over the security of that device. As we discussed, reasonable security measures are required by the Gdpr and several other laws, so make sure you take this one seriously. Okay, vulnerability testing and audits. So if you want to know how easy it is to hack into your database, the best thing to do is to hack into your database. This will give you an idea of any holes and any vulnerabilities that are out there and allow you to fix them before someone else finds them. Also, audits are a great way to identify any issues. You're probably already doing this per applicable law. Always follow the auditor's recommendation. It definitely helps in a breach situation. Okay, subcontractors. So unfortunately, a subcontractor's breach is your breach as well. Choose your subcontractors wisely, make sure they have appropriate security measures in place, and hold them to these standards in your subcontract with them. A technology vendor should be PCI compliant, have a written privacy policy, encrypt data at least at rest, have a single sign-on capability, a business continuity policy, a disaster recovery policy, hosting policies, ISO certification, an incident response plan, and a risk assessment policy. Ideally, you should have the right to audit your subcontractors to confirm their compliance. And if you're going through this presentation, you're part of a small company and you think you're safe because you don't work at Google or Facebook, just be aware that that may have been the case once, but unfortunately that's not how the world works anymore. Hackers know that smaller companies are not always sophisticated when it comes to security and therefore could be easier targets. So protect yourself no matter the size of your company. What not to do. So a great example of what not to do is the recent Uber hack. What happened there was a hacker stole 57 million driver and rider accounts, and instead of doing their due diligence and performing their legal duties, the company paid $100,000 ransom to hackers to keep quiet, which is essentially a decision to fund organized crime and goes directly against the statement that the FBI had made in 2016 not to pay ransom to hackers. The deal was arranged by the company's chief security officer, and it was made to look like a deal where they paid a company to do vulnerability testing on their software. This is just crazy to me. I could have used Yahoo or Equifax as an example here, but you know, the Yahoo breach was much larger in size, and the Equifax breach involved a lot more sensitive personal data. But this Uber one was it's just crazy. Really, please don't do this. You're going to want to face issues head on and take responsibility and accountability for them, because if it comes out later that you didn't do that, then it's not going to be pretty. There's really no way to come back from that. Okay, so say that you have taken all the necessary steps to ensure data security, but you're still hacked. Unfortunately, in this day and age, this is a definite possibility. So what should you do? First, research. Work quickly to identify how you got hacked, what information was compromised, and what vulnerabilities that the hackers were able to take advantage of. Identify just as quickly, work with your lawyers, whether in-house counsel or external or both, to identify the laws that apply and make sure that you do everything to follow them. As we discussed in the slide about state breach notification laws, there are sometimes some deadlines that you need to comply with, and sometimes an investigation needs to be done before you're able to figure out whether you need to send those breach notification notices. So this is something that needs to be done as urgently as possible. Okay. You can follow the laws that you've identified to notify affected individuals. I would also recommend contacting any businesses who were victims of the breach, even if not legally required. Transparency and cooperation is the best way to recover from a breach situation, as we just discussed, even if it's not the best news to give your clients or suppliers. Okay. You'll also need to follow internal policies, make sure that you're in compliance with those. If those are robust policies, then you're going to, be doing your due diligence just by following steps A, B, C. It's going to be much easier to do than trying to figure it out on the fly. A breach is a situation that requires fast and thorough action from a number of players. Don't be afraid to invest in outside security contractors to help you. Engage your internal security staff to make sure that any issues are dealt with as soon as possible. Okay, questions? Okay, so it looks like we have a few questions here. The first one, and this is actually one that I've heard before, so it's definitely a good question, is are processors under the GDPR able to contract away their obligations? And it's sort of interesting because I've heard kind of rumors floating around, and I even heard in another webinar that I attended that processors don't have any direct obligations under the GDPR. That's absolutely not the case. That used to kind of be the case under previous EU law. There were no, direct fines that the EU regulatory authority could go after with regard to processors. That is not the case anymore. Processors have independent duties under the GDPR and can be directly fined under them. So there are certain risks that we discussed that can be in a contract between a controller and a processor. But the answer is no, a processor cannot contract away their obligations under the GDPR. Okay, and by the way, as I'm going through these questions, you guys can definitely type in other questions into the chat box. But I'll move on to the next one here. Okay, since the GDPR and e-privacy regulation only apply to EU residents, should we put those protections in place only for EU residents or for all personal information that we collect, regardless of the individual's residency? So this is another good question. Technically speaking, under the GDPR and e-privacy regulation, you only have to do this for EU residents' data. At the same time, though, it's going to be kind of difficult to go through and say, okay, is this person an EU resident? Is this person an EU resident? It's going to be hard to kind of pinpoint that, so you know whether those responsibilities, requirements need to be in place. Also, I will add that, at least in my view, the GDPR and e-privacy regulations are kind of setting the stage for how laws are going to look in the future globally. So by complying with the GDPR and e-privacy regulation with regard to all the data you collect, regardless of the residency of that individual, you're going to be setting yourself up for success in the future to make sure that you're going to be in compliance with every law that might come into being. Okay. So this one is, what if the GDPR conflicts with US or other law that we are required to follow? So, all right. So as far as other laws, there might be laws out there that say, you need to retain certain information for a certain amount of time, and the GDPR says you need to get rid of that information as soon as you're done using it. There is an exception for use of processing of data under the GDPR that essentially says if you have a legitimate basis for processing that data, even if the individual hasn't consented to it, then you can process that data. So in this instance, if you have financial data you need to hold on to per US law, then that's going to be kind of an exception to the GDPR. And I would never tell my company, at least, to not follow laws in the local jurisdiction just because EU law says something else. So don't worry about that one too much. I know it's kind of one of those things that comes up and you're like, oh my gosh, they didn't think about this, but they kind of did. So shouldn't be too big of a deal. Okay. Let's see. Okay, in a data breach situation, can we also call victims in addition to giving them legal notifications? The answer is definitely yes. I would actually recommend doing this. This kind of gives an in-person touch, like a personal touch to the situation where you call someone, you say, hey, listen, this happened. We're doing what we can to make sure it never happens again. We're legitimately sorry, and we want to make sure that you're able to protect yourself, and we're going to send you a letter that kind of tells you how to do that. So it's just kind of a nice way to make sure that you're maintaining those relationships and going above and beyond your legal duties to make sure that you really do care about the people whose information was breached. Okay, let's see. Okay, so we have one that says, historically, hotels and other meeting venues have not agreed to contract language related to GDPR. Do you see this attitude changing, or do you anticipate they will add this language to their standard agreements? So essentially right now the GDPR isn't in effect yet, and I've seen some resistance to it based on that. I would expect that, once you can say, hey, it's actually in effect now, we can be fined, then they're going to accommodate it. They're going to have to. Okay, any other questions?
Okay, that looks like that is all the questions that we've got. If you've got any more, make sure type them in really furiously here. We'll wait just another few moments in case anyone's got something burning. Otherwise, we will have a recording of this presentation available. We'll send this out to everyone who attended today. If you've got any other questions, we'll have some contact info in that email as well to help you reach out. Thank you everyone for coming and for listening in. I hope this was helpful. This is going to be a pretty big deal for everyone worldwide. So good for you for paying attention early. So all right, with that, I will leave you all. Have a great day.